Dateline, New York, September 28, 2016. Disgraced former Congressman Anthony Weiner revives the Clinton email scandal. He and his estranged wife, Uma Abedin, Clinton's top aide, once shared a Dell laptop. Thousands of Clinton and Abedin emails are on it, some of them classified. Abedin forwarded some of them, others were backups from other devices. On September 28th, Weiner's attorney turns over a huge cache of the email to Preet Bharara's office. He's the U.S. Attorney for the Southern District of New York. Weiner, whose sexting scandals forced him from office, is now under federal investigation in a sexting case involving an underage girl. September 28th, Washington. FBI Deputy Director Andrew McCabe is informed of the emails. So is Peter Strzok, the lead investigator in the Clinton case. Strzok fires off a message to his frequent texting partner, attorney Lisa Page, who works for McCabe. Called up to Andy's earlier, Andrew McCabe. Hundreds of thousands of emails turned over by Weiner's attorney. Includes a ton of material from spouse. McCabe knows the emails are significant, but takes no action and doesn't brief FBI Director Comey. Doesn't tell the Justice Department either. Dateline, October 3rd, New York. The FBI's New York field office seizes Anthony Weiner's laptop, finds the sexting evidence and the Clinton-Abedin emails, some or all of which Weiner's attorney had already turned in. On October 3rd in Washington, it's a sunny 77 degrees, a nice day to do nothing. And at the FBI headquarters in D.C., that's just what McCabe and Strzok were doing. Nothing. A conservative treehouse analysis of FBI text messages finds no talk of investigating the content of the emails. The focus is on the issue of the emails, and do they have probable cause to look at the emails? McCabe, Strzok, and Page were the only ones in official Washington to know about the emails until October 21st, when Preet Bharara, the U.S. Attorney in New York, called the Justice Department. Hey, anybody interested in these Clinton-Abedin emails?
The prosecutors in New York who were working the criminal case against Weiner called down to headquarters and said, are we getting a search warrant or not for this? That caused, Justice Department headquarters to then call across the street to the FBI and poke the organization, and they started to move much more quickly. I don't know why if there was slow activity, why it was slow for those first couple of weeks.
Why the delay? We'll cover that shortly. First, let's look at what happened. Recall September 28th, McCabe learned of the emails. But it wasn't until October 27th that he and other agents briefed Comey.
And they laid out for me what they could see from the metadata on this fella Anthony Weiner's laptop that had been seized in an unrelated case. What they could see from the metadata was that there were thousands of Secretary Clinton's emails on that device. They said, we think we got to get a search warrant to go get these. And the Department of Justice agreed we had to go get a search warrant. So I agreed. I authorized them to seek a search warrant.
The next day, October 28th, Comey reopens the investigation. 2 days later, October 30th, the FBI gets this search warrant to start scouring the laptop.
And they found thousands of new emails. They found classified information.
After 6 days, the team reports in.
And then called me the Saturday night before the election and said, thanks to the wizardry of our technology, we've only had to personally read 6,000. We think we can finish tomorrow morning, Sunday. And so I met with them. And they said, we found a lot of new stuff. We did not find anything that changes our view of her intent. So we're in the same place we were in July. It hasn't changed our view. And I asked them lots of questions. And I said, okay, if that's where you are, then I also have to tell Congress that we're done.
Case closed, again. But there are many unanswered questions. There were reportedly 650,000 emails on that laptop. In this letter to Congress, the FBI said it reviewed 49,000 that might be related to the mishandling of classified information. That leaves roughly 600,000 emails that weren't reviewed but could be in, say, any investigation of the Clinton Foundation or the Uranium One deal. FBI Deputy Director Andrew McCabe stalled the investigation into the Weiner laptop for a month. To learn why, let's briefly revisit our earlier series titled The Assault on the Constitution. In it, McCabe is named as part of the scheme team, officials at the FBI and Department of Justice whose illegal mission was summed up best by former U.S. Attorney Joe DeGenova.
The facts are now so strong that there was a brazen plot to exonerate Hillary Clinton and then if she lost, frame the President of the United States with a false crime.
Recall this now infamous text message between two members of the scheme team, Peter Strzok and Lisa Page, about a discussion that occurred in McCabe's office. Strzok writes, "I want to believe the path you threw out for consideration in Andy's office, that there's no way he gets elected, but I'm afraid we can't take that risk. It's like an insurance policy in the unlikely event you die before you're 40. The scheme team's insurance policy was the FISA warrant issued October 21, 2016, and renewed 3 times in 2017. It was used to spy on Team Trump, hoping to turn up evidence to smear him before the election or force him to resign if he won. McCabe signed off on one of the FISA warrant applications, certifying its accuracy. But did he tell the truth, the whole truth, and nothing but the truth? No. McCabe didn't tell the Foreign Intelligence Surveillance Court the search warrant application was based on the phony dossier about Trump, that the information was unverified, that it was not corroborated, and that the dossier was paid for by the Clinton campaign. In Washington speak, McCabe was exhibiting a lack of candor. Most people just call it lying.
I would consider this the largest law enforcement scandal in history for this reason. The activities of McCabe and others were designed to subvert the Constitution and a national election, the most serious offense under our Constitution.
McCabe protected Clinton by stalling the investigation of the Weiner laptop, hoping to keep it under wraps until after the election, maybe forever. What's McCabe's link to Clinton? Let's flash back to 2015. Democrat Terry McAuliffe is governor of Virginia. He urges McCabe's wife, Dr. Jill McCabe, a physician, to run for state office. He funnels $467,000 from his political action committee to her campaign, then arranges for the state party to chip in $207,000. Altogether, he delivers more than a third of her campaign funds. McAuliffe has also raised money for the Clintons, the first family of the Democratic Party. In addition, he served as co-chairman of President Clinton's 1996 re-election campaign and chairman of Hillary's 2008 campaign. And they campaigned for him when he ran for governor in 2009 and 2013. Obviously, he's in their inner circle. A successful politician, why he thought Mrs. McCabe would be too is anyone's guess. Dr. Jill McCabe lost to the Republican incumbent. As for the link to Andrew McCabe, she lost before his promotion to number 2 at the FBI. She lost before he supervised the Clinton case. Still, it seems obvious that Andrew McCabe should have recused himself as soon as he came into contact with the Clinton case. He didn't. Then on October 24th, the Wall Street Journal broke its exclusive story. Clinton ally aided campaign of FBI official's wife. Donald Trump, campaigning in Florida, summed up the tainted FBI investigation in a few words.
No wonder they found nothing wrong. We have to investigate the investigation, folks. Our system is rigged.
It sure looked that way, didn't it? And that's Andrew McCabe's fault and his alone. The Wall Street Journal story prompted a lot of chatter at FBI headquarters in Washington, where Strzok and Page are texting each other. Here's an analysis of their text by the Conservative Treehouse website. FBI investigative team wanted McCabe to stay on the case, particularly Lisa Page, who was special counsel to McCabe. But other texts revealed disagreement involving Jim Rybicki, the chief of staff for FBI Director Comey. Here's Page's text. Rybicki just called to check in. He very clearly 100% believes Andy should be recused because of the perception. And in this November 1st email, McCabe took himself off the case. He said, "As of today, I am voluntarily recusing myself." But with the campaign in its final days, nothing could legitimize the sham Clinton investigation. In March 2018, McCabe was fired after lying under oath to federal investigators about leaks to the media. The case was referred to the U.S. Attorney for prosecution. Why did Anthony Weiner's lawyer turn over the Clinton-Abbott emails to Preet Bharara, the U.S. Attorney in New York? At the time, Weiner was facing sexting charges involving an underage girl. Maybe his lawyer thought the email stash was a get-out-of-jail-free card. The conservative Treehouse wrote, "There's a solid case to be made that the emails Anthony Weiner's lawyer brought to Preet Bharara was Weiner's leverage to escape prosecution." The strategy failed. He pled guilty. Weiner was sentenced to 21 months in prison. But no charges were filed against him or Abadan, though the FBI found classified information on their laptop. Why no charges? FBI Director Comey faced that question at a Senate Judiciary Committee hearing.
Why did you conclude neither of them committed a crime?
Because with respect to Ms. Abadan in particular, we didn't have any indication that she had a sense that what she was doing was in violation of the law. Couldn't prove any sort of criminal intent. Really, the central problem we had with the whole email investigation was proving that people knew, the secretary and others knew that they were doing that they were communicating about classified information in a way that they shouldn't be, and proving that they had some sense that they were doing something unlawful. That was our burden, and we weren't able to meet it.
To this day, Comey insists he needs to prove criminal intent to bring charges. But intent is not required according to legal analysts, including those at Judicial Watch. It's leading the fight to get the emails released. One batch made public was significant.
It places classified information on the Weiner laptop. It beyond any doubt, according to the State Department themselves, proves that classified information was forwarded in an unlawful way. It's a direct violation of Title 18 of the U.S. Code, Section 793F, which is mishandling national defense information. Your earlier clip with Mr. Comey talking about intent is a fraud. There's no requirement for improving intent under that particular citation I gave you a moment ago. Intent is irrelevant. The fact that the loss or the mishandling of the national defense information occurred, that's the crime.
Fox's Ed Henry cited another Comey statement about intent.
Abadan didn't have a sense she was violating the law.
It's
I've
irrelevant.
never heard of such a thing.
It's irrelevant, and no one, let me tell you, no one in the armed forces, the intelligence community, or law enforcement, no one listening to this program tonight who has ever had a security clearance would ever buy that kind of phony excuse. And so this really cries out for a legitimate investigation being done.
And there's more than enough evidence on that laptop to do just that.